Hi, I'm Vivian Dempsey. This is the Writing Edge Bar Review course. I'm now reviewing Performance Test B from the Winter 2015 Bar Exam, State v. Daniels. And I'm talking about Issue 1 for Gloria, which would be excited utterance. Okay, so this is what your issue sheet would look like for Gloria, excited utterance. Okay, so the evidence code defines an excited utterance. It's evidence code 8032. And it defines it as a statement that while still under stress from a startling event. Okay. Now, there are two, a statement about a startling event while still under stress from the startling event. Okay. So that's the first piece here, is whether or not it was actually a statement. Because if they were just random body movements because of her brain injury, then they weren't intended by her as assertions, and they wouldn't be statements, and excited utterance could therefore not be an exception. Okay. The second piece of this is the Jackson case that talks about whether the statement was made while the person was still under the stress from the event. Okay, the truthfulness or the trustworthiness of the hearsay exception, the thing that allows it to come in without cross-examination of the witness, is that they didn't have time to fabricate. Okay, they were, just babbling out what had happened. Okay, and normally, these if these were statements, then Gloria was making them probably within an hour of having been beaten by her son. And that's certainly, in terms of the time frame, is short enough. But that's not the only consideration, as the Jackson case discusses. It also requires that that other things that can be considered in terms of whether they're still under stress is their emotional state, their demeanor, etc. And here, what was interesting is that the paramedic who administered the IV sedation to Gloria so that he could intubate her has an affidavit saying that he had given her this IV sedative. Well, think about it. We're talking about, first of all, a person whose body movements are kind of like this, and second of all, a pretty delicate procedure of opening, surgically opening up her chest in order to stick in a tube. You'd want to make sure she was sedated sufficiently for that. So I'm thinking the sedation is fairly heavy for that. Okay, and the paramedic reports that he could tell that the sedation was working. Then the police officer, after that happens, while Gloria's already on a gurney, then he says, listen, I want to talk to her for a few minutes. Who did this to you? She's already sedated. So it's entirely possible, or it's arguable, as the criminal defendant, representing the criminal defendant, that her statement is not while she's still under stress from a startling event, because she was sedated. So either it's not a statement at all, they were just random body movements, or if it is a statement, it wasn't while she was still under stress because she was sedated. And those are the two issues as it relates to Gloria, excited utterance.